call it a mixed bag. Some of the issues that were appealed by the Attorney General and the IEBC as well as other appellants have been accepted by the Supreme Court judges, and there are two key issues that have been rejected, particularly the question of creation of new constituencies, the 70 new constituencies that was in the second schedule of the Constitution of Kenya Amendment Bill of 2020. And the second question that has been rejected by the Supreme Court judges is the question of whether President Uhuru Kenyatta can initiate a process of amending the Constitution through a popular initiative. And the Supreme Court judges stating that the President actually initiated this process and was an active participant in the process of amending the Constitution through a popular initiative. We are trying to get reactions from some of the lawyers who represented various parties in this particular matter to get their immediate reaction to what they think the judges considered when making that decision and whether they agree with the decision. But this is the court of last resort. So whatever has been determined by the judges remain the situation as it were. And the fundamental question that now many lawyers are asking is what then is the fate of the Building Bridges initiative? What is the fate of the bill that was brought to IEBC by the promoters of the process, and what would be the outcome if they were to proceed? Now, let me talk to Professor Ben Sihanya. He was one of the appellants representing the Building Bridges initiative team. Professor, the verdict is out. Yes. What is your immediate reaction? And the fundamental question that our viewers are asking out there, what is the fate of the BBI process?
The fundamental issue, Mr. Gachuri, is this, Francis, that can Kenyans debate on constitutional amendment? The answer, the court has said yes. And this is by saying that the question of the question that Building Bridges initiative was talking about was how to amend the constitution and what they could amend. So they didn't go into details about the content, but the main issue is the so-called basic structure doctrine, which is an alien doctrine. It's not even a doctrine in constitutional law as far as we are concerned, is dead in Kenya. It's not applicable, and that's the main point. The main point is that Kenyans can debate constitutional amendment in future. So if we didn't do it this past time, it means Kenyans can debate the amendment of the, and which is absolutely necessary for Kenyans to amend the constitution along the lines that were discussed in BBI.
There were seven key issues actually, yes. And my hearing over the judges are saying they seem to have disallowed the appeal on account of two particular issues: yes. Creation of new constituencies, the 70 constituencies, yes. And the participation of the president as an initiator of the popular initiative. So then, in totality, what is the fate of the bill?
Well, the fundamental issue is, we repeat, that Kenyans can debate constitutional amendment. The two issues in which the court was, 2 out of 7 really, in which the court was saying that they disagreed with the BBI process are mainly issues of process. Even them, they were saying, some judges were saying it's possible for the president to participate at a certain level because of Article 38 of the Constitution. It's possible to change the constituencies, etc., if you follow a certain process. So these are case-by-case issues, which means that even in the future, these issues can still be addressed on a case-by-case basis.
Would you say then, Professor, that there now exists clarity on the process of amending the Constitution, even if you don't go to the content of what should be amended or what should not be amended, there is now a proper, clearer mechanism of how to do it?
Absolutely, and I think the Supreme Court, as we expected, it has risen to the occasion by clarifying very well that we need to be sensitive about process. And on most issues, BBI did the right thing, and therefore it's in the future it's possible to do it and just on a case-by-case basis, looking at some of the areas where there may have been challenges. Yeah.
Interesting. Now, I'm also trying to see whether I can be able to speak to Waweru Gatonye. Waweru Gatonye was the lawyer representing the president in this particular matter. All right, he has declined, and we respect that opinion. Let me also try and talk to a few more lawyers who are in this particular matter. One of them is Morara Omoke. He was one of the participants in this particular process. Morara, what would be your immediate reaction of this judgment by the Supreme Court judges, and what does it mean moving forward?
The first thing is that the BBI has been confirmed to be totally nullified. It cannot come back unless it's started afresh. That's the first thing that is coming out of this decision. The other thing is that a number of issues have been settled with finality, that the basic structure, this doctrine does not apply in Kenya. Of course, to disappointment of many people who were advocating for that principle. But the good thing is that in the end, what counts is that whenever there's any effort to amend the Constitution, we shall always have the steps that are basically provided in the Constitution. Public participation, very important, as you can see in the decision. That has been found to be one of the reasons why the BBI was found unconstitutional. So that is very solidly within that requirement. Then we must always have a referendum. Of course, the court has shied away from deciding whether we should have a multiple choice referendum whenever we have a referendum. Or again, to the disappointment to some of us who really wanted to have that properly decided, but they said they would like to postpone that to a later date. So if we have a referendum in the future, of course that question will arise. It can be addressed at that point in time. Yeah.
Now there were questions as to the procedure, the mechanism of amending the Constitution. Would you now say there now exists a proper mechanism that in future, should anyone want to initiate the process of amending the Constitution, there now exists a proper roadmap to do that?
Totally. There's clarity. When you look at the totality of all the three decisions of the High Court, the Court of Appeal and the Supreme Court, you can come up with in summary, I can tell you one of the issues that will come out is that whenever you want to amend the Constitution, you must do proper public participation at the time when you initiate that particular process, and when you publish the bill. You must publish the bill according to Article 7 of the Constitution. You must make sure that it's in at least not just English, but have Kiswahili. Publish it nationwide, provide the people with the copies so that they can read before you collect the signatures. And once you collect the signatures, then when you move to the other stages of the process, that is the county assemblies and the parliament, you must have proper public participation. So that has been made very clear. And then other things that will be decided, of course, now we do not know what is the nature of the referendum. That is remaining for determination at a later date.
Mm-hmm. Now, there are obviously legal and political consequences to the decision that has been made, has been rendered by the judges this morning and afternoon. In a nutshell, what would you say these are the political and legal consequences of the judgment rendered today?
The political consequences is that, number one, we cannot alter the structure of government at this point in time. We cannot increase the size of the parliamentary representation at this point in time. So unless this is done at a later date, and it means starting afresh. So politically, we are moving into an election now, just about less than 140 days left.
130 to be precise.
130 days left. So within that time, it's not possible to do anything doing with an amendment to the Constitution. That has to come after the election. And I can tell you, we have the two candidates, the Deputy President and Raila Odinga. If any of them wins, I can tell you they will not allow anything looking like BBI. Ruto is very clear at this point, he cannot do it. Raila is not clear, but if he was to win that seat, he will not accept to have a prime minister, especially having been in the last, when we had a prime minister in this country, he knew how difficult it was to operate. Prime minister and president, we will not have it. So the idea of amending the Constitution might take a longer time. It could be maybe 5 years from now before we hear another idea about amending the Constitution, or even longer than that.
Then what does it say, Wakili, in terms of if there were issues that needed to be amended in the Constitution? Are you saying that it would be very, very difficult to do that, even when you have a place in that Constitution that pinches, that you have to live with it because the process will be more and more difficult?
Of course, they have not said the process is difficult. What the courts have said here today is that this process of amending the Constitution from now onwards is just a balance between flexibility and rigidity. So the process is you can always amend the Constitution, but you must comply with the norms set out in the Constitution. Mm-hmm.
Yeah. Lastly, what do you make of the pressure that was coming from various quarters on the Supreme Court judges? Do you think they have acquainted themselves well in how they have rendered this judgment and the reasoning behind the decisions that they have made?
You see, for the judges, you have to do your responsibility. I don't think there was pressure from anywhere, to the extent that I know, unless it was happening behind the scenes. But from to the extent that I know publicly, there was no pressure on the judges. In fact, all the issues had been determined already by the High Court, by the Court of Appeal. When you look at the decision made by the Supreme Court, what they have tried to do is to distinguish from the other judges. On that, of course, I have my personal opinion is that I disagree with some of the analysis by the Supreme Court judges, which made a presumption that the other judges, there were 5 judges in the High Court, there were 6 judges in the Court of Appeal, that those ones, they knew less than the judges who decided today. But that one it's within their right. As a judge, they can decide. They are not bound by the High Court or the Court of Appeal. So in my personal opinion, I disagree with some of the issues, but that is how the law works.
Attention was also on Chief Justice Martha Koome. This arguably was her first major assignment since her appointment. How would you look at how she has dealt with the matter and the attention that was on her?
That one is a matter of history. I will not make judgment today. We have to get the entire judgments, we read them. But I would say, having had that determination today, history and God will judge the lawyers, the parties, and the judges. So if a judge made a determination which may not look as very solid in the law, that one the scholars will analyze, the history will make a determination.
Then in a nutshell, Wakili, before I let you go, I keep seeing a lot of SMSs asking me, ask those lawyers, then what becomes of the BBI document? Does it mean it is shelved? Because some of the issues seem to have been allowed, but some of the issues have not been allowed. Some say it's a mixed bag, but the totality of it, what is it?
The totality is this, when we approached the courts, I was, as you know, one of the parties who challenged the BBI. When I filed my petition, I raised as many issues which I found to have been failures by the promoters, the president, because the promoter was the president and the former Prime Minister Raila Odinga. I was able to identify all the things that they did not do in accordance with the Constitution. So what comes out of this process today is that while the court has determined many questions, the result is that the BBI has been nullified. That's the outcome. The many issues that have been determined, those were issues we raised, because when you come before the court, you come with arsenals. You raise many points of law, and the hope is that either you succeed in all of them or at least some of them. So for the BBI, it had to fall down for one reason or the other. And two things, it couldn't succeed because of public participation. It couldn't succeed because it was a presidential initiative and not a popular initiative. But in terms of the content, if the politicians if they truly mean their word, may they proceed very quickly to Parliament and pass the tax exemptions that they had in the BBI, but let them not alter the government structure because they cannot, obviously. But for anything that was good, they wanted to increase the county funding to the counties. Let them proceed and provide. The minimum is 15%. If they want to do 35, 50%, may they do it. But let us ensure that all these funds that are being sent to the counties are properly utilized, because we know there's been a lot of wastage in the counties. We know that. We know there's been misuse of the funds, buying things at the wrong market prices. So that one, let them proceed and increase the funding, but ensure proper utilization.
Thank you very much. That was one of the petitioners of the BBI process, right from the High Court to the Court of Appeal, and even defended the decision of the Court of Appeal and the High Court here at the Supreme Court. Now, let me look for Paul Mwangi. He was the secretary of the BBI process and one of the appellants in this particular matter. Paul, all attention was on the appellants, the Attorney General and the BBI team, as well as IEBC. In a nutshell, what do you make of the judgment today?
Well, what I think we lost the process on is what the judges thought was the faulty involvement of the president at the time of initiation. They have upheld what was done at the task force. They have upheld what was done at the select committee. So all the processes up to the time when the promotion was started has been upheld. What they have faulted is they said the president did not disengage sufficiently from the process by the time we decided to do the popular initiative. And they said it is still open for him, should he wish, to do this through a parliamentary initiative, and they have recognized that as a method that is open to him, and that in my reading it would mean that if you want to have a popular initiative, then you would have to step away from the process entirely.
This kind of a process and the judgment that was rendered today was obviously going to attract the dichotomy of winners and losers. How would you deal with that matter?
Well, the most critical thing that we were most worried about was the fact that the power of amendment had been taken away by the basic structure doctrine. And had we lost on the issue of the basic structure doctrine, it would mean that you cannot reload this matter. And all the judges, apart from one, have denounced the basic structure doctrine. It means the right of any Kenyan and the right of BBI to propose amendments remains or has been reinstated. And it is up to whoever, either us or whoever else who want to pick it up, to decide when they want to come back to it.
Paul, you arguably is the face of BBI, so to say, and the constitution, the attempt to amend the constitution. From where you sit, are there things that you say, listening to the judges, we missed that point, or this point was missed, that it could have been done better? Is there, in hindsight, something that the judges have said that you realize that probably could have been done better if the situation or the process was to go on to its conclusion?
I don't agree with their reading about the fact that the president was part of the promotion. Because even when it comes to a political process, the president does get involved in a political process. He votes, and they say the same thing also, that he votes, he campaigns, and I did not see any role he played at the time when the process started that I can say would have been an involvement in the promotion process. But notwithstanding that, possibly if we were to go back, it would have a better separation. Or a more clearer separation. But I do not agree that, for instance, when we held a process to collect signatures, which the president came and Honorable Raila came, I do not view that as participating in a promotion in a way that you can say would totally delegitimize it. But that is their ruling, and if I were to say, would I go back and state something, possibly that's the one thing I would change.
Then respond to this question that I see many people asking. What then is the fate of BBI? Because variously you've seen, I'm sure by now you've seen the discussion on social media and elsewhere that the BBI process collapsed at the High Court. It died at the Court of Appeal, and some argue now it has been buried at the Supreme Court.
No, the reason everybody thought it was dead is because the power to do so had been taken away. And that power has been brought back. So now it is a question of the political leadership to decide how they want to deal with the matter from here henceforth. Does the president want to deal with it now? Because the court has said he still has options into it. Do the political leaders want to start the BBI issue now, particularly in the light of the fact that we are going for an election? Or does the fifth want to pick it up when he becomes president? So
Paul,
that is his decision also.
Look, other than the legal issues raised in court, at the High Court, at the Court of Appeal, and here at the Supreme Court, the BBI process has also been a very heavy political matter. What, from your reading, are the political consequences of the judgment that has been rendered by the 7 judges today?
I think the only question that arises is when it would come back, and whether if it came back, it would come back with all the issues. So it is a time for the political leadership and all the other proponents of BBI to decide whether you want to reload all the issues, whether you want to reload some of the issues. There are still issues that were very roundly popular across the political divide. So a decision will have to be made whether you want to reload those only, or you want to go back and start another process that can bring up those issues, maybe even more issues, now that the power has been reinstated.
One of your long-term clients, former Prime Minister Raila Odinga, has variously said that reggae went on a break. Would you now say reggae has been taken away completely, or it can be reintroduced? It can be reintroduced.
It can start the second, but that's what I'm saying. He says we have finished the first match, the first half. So it's a question of when does he want to start the second half, and does he want to start it himself? As I said, he is the fifth, so when he comes, he will decide whether he wants to start the second half.
Paul Mwangi, the former secretary of the BBI Secretariat. I started this live broadcast earlier with Nelson Havi, President Emeritus of the Law Society of Kenya, and He didn't seem smiling that time. Now he seems to smile. Why?
Well, the people of Kenya have been vindicated. The Supreme Court, which is the last court of mistake, as we say in the legal parlance, has declared, as did the High Court and the Court of Appeal, that the Constitution of Kenya Amendment Bill 2020, famously known as BBI Bill, is unconstitutional. It has arrived at that outcome on account of two fundamental grounds. One, that this initiative was not a people-driven initiative, but was one which was an enterprise by President Uhuru Muigai Kenyatta and his brother, Right Honorable former Prime Minister Raila Amolo Odinga. And you see, the Supreme Court, just like the High Court and the Court of Appeal, have demarcated the parameters as to what can be done by the people and what can be done by Parliament, either directly or through those who control Parliament. Number two, the Supreme Court has agreed with the High Court and the Court of Appeal, and by extension our arguments, that there was no adequate public participation in the process towards the initiation and the promotion of this bill. It is a landmark decision. It is one that will go a long way in shaping the democratic space in Kenya today, henceforth.
Now, Wakili, the question of amending the Constitution, probably it will recur in future or in days to come. Would you say that the judgment that has been rendered by the judges today has now offered a clearer roadmap on how to do it?
There's always been a clearer roadmap on how to do this thing. However, President Uhuru Muigai Kenyatta has always taken the Constitution of Kenya as an inconvenience in his administration. Had they done the right thing, had they purposed to amend the Constitution, they ought to have pursued this process through Parliament. And if it was a concerted effort by President Uhuru Muigai Kenyatta and Right Honorable Prime Minister Raila Amolo Odinga, they had control of Parliament, they could have done it. But they decided to take the role of the people, Wanjiku, Atieno, Nasimiu, Hassan. That is wrong. So that going forward, anybody who is desirous of amending the Constitution must stick to his or her lane, as one of the judges has said here. And it's plausible that this enterprise may be pursued in future, but it has to be done within the parameters of the Constitution. There is nothing wrong about amending the Constitution. There's even nothing wrong about dismembering the Constitution. Only that if you have to amend, you follow the procedure. If you have to dismember, then you are, for all practical purposes, creating a new constitution. You follow the four sequential steps enumerated, and which are historically and lawfully a prerequisite to the making of a new constitution.
One of the heavy discussions, Wakili, during these proceedings, right from the High Court to the Court of Appeal and now the Supreme Court, basic structure doctrine.
Yes.
And the judges have said it doesn't apply in the Kenyan constitution or in Kenyan context. What do you think about that judgment?
Look, a doctrine is just that. It's a doctrine. You will not find it written anywhere. Like the Trinity, you will never find the Trinity in the Bible. You understand? Separation of powers and the independence of the judiciary will not be found anywhere in the Constitution. Of all these judges, only Justice Mohammed Ibrahim appears to have appreciated the point and agreed that the basic structure doctrine applies in Kenya. But that notwithstanding, we are contented with the decision of the court. The issue of the basic structure is one that scholars will now have to examine in the near future. They have not said that it will never apply in Kenya. They have said maybe it's not yet time for it to apply in Kenya. Maybe it may apply in Kenya. And look at what we've done. We have held this aggression by President Uhuru Muigai Kenyatta and Raila Amolo Odinga at bay. Had we not done this, they would have dismembered the Constitution in 70 ways. You understand? So perhaps when I'm long gone and dead or very old, the basic structure doctrine will be revived. And it can only be revived if the aggression that we have witnessed by President Uhuru Muigai Kenyatta and Raila Amolo Odinga repeats itself. If it doesn't, then we don't need to pursue that doctrine. You understand?
Lastly, this discussion, other than what you as lawyers have argued in court, this has also been a matter in the political arena.
Yes.
What then would be your view on the political consequences of the judgment that has been rendered today?
This judgment is very impactful in several ways. 4 years have been wasted. The four big agenda a very noble initiative by President Uhuru Muigai Kenyatta and his deputy, Dr. William Samoei Ruto, was intended to ensure social economic development in Kenya. We have not developed. Everybody is poor. Everybody is in a Fuliza mode. Why? Because he was sidetracked from the performance of his duties. You understand? Let parliament be emasculated, purchased the opposition with the hope that there will be peace and tranquility. But there has been no development. Going forward, I think it is imperative, especially for us, of the Kazi ni Kazi initiative, to continue our messaging that what is important right now is not the amendment of the Constitution to make provision for a few individuals, but the implementation of the Constitution to ensure that there is economic and social development from bottom up, so that everybody has money in his or her pocket, so that we get rid of these Shylocks, we get rid of Fuliza, we get rid of credit reference bureau that have encumbered social economic development to that extent. Now, those on the other side that said BBI will be back, reggae taking a pause. This is a big setback for them, and it's also a vindication, a point that the people of Kenya must understand. You cannot lie to the people of Kenya all the time. An end to this lying has come, and it is today.
I see how you have swapped the legal cap with a political cap,
Yep.
because Harvey is also vying for a parliamentary seat in Westlands, yes. And I will not give him an opportunity to go beyond there because he will start campaigning. Let me now talk to Ocheng Dudley. One of the key highlights of this particular matter was the role played especially by what you'd consider young lawyers. You are one of them. What would you think of this opportunity to argue the BBI matter before the High Court, the Court of Appeal, and finally before the Supreme Court judges?
Not so young, Gashuri, but I think it was a good opportunity for the younger lawyers, I would use that term, to showcase their skills. And that's something that the court has also spoken to. It was a moment in history, and I'd say I was lucky to be amongst those standing on the cusp of this historic moment.
I've asked your colleagues in the legal fraternity what their reaction, what their views or their opinions of the judgment rendered by the 7 judges today is. I would pose the same question to you.
I think reggae is off for now, but it makes it really easy for reggae to come back, because the basic structure doctrine is what protects the Constitution from invasive changes. So as long as someone follows the procedure in future, you garner the numbers. You remember Njoki, Supreme Court judge, saying it's about the numbers. Then it's easy for one to propose any kind of changes to the Constitution as long as they gather the numbers. And that's why I think Justice Ibrahim's opinion was really important. Remember, Justice Ibrahim is a second liberation hero. He lived the struggle for a new constitution. He knows what it means when the president is a supreme, for example. The president is imperial. So there's a lot of value in his dissenting judgment.
Is there a particular part of the judgment by all the 7 judges that you'd say, I disagree with that particular one? Even as you say, on some other parts, I agree. What is it that you say in a compelling manner you totally disagreed with?
I totally disagree with Justice Njoki's saying that it is the numbers that matter, especially as we're heading to a new election, where it's about numbers, but it's also about the quality. I don't think it was completely correct for her to say that a popular initiative depends on the numbers, 1 million, majority of counties or simple majority at the ballot. It's also about who, because that process is clearly separated. And I'm glad that that did not become the majority opinion.
Having participated in this process, right from the High Court to the Supreme Court finally, for future proposals or attempts to amend the Constitution, what in a very short way would you say are the do's and the don'ts?
The do's, I think the president is out. That was carried by majority of the court. The issue of public participation, nearly all the judges have said it was inadequate, or if it wasn't inadequate in their view, then nearly all of them have called for legislation to outline the process that should happen. And I think in that, the message has still been that Constitution is about the people. They need to be involved deeply in it.
Thank you very much, Ocheng Dudley. Vicky, that is the situation here at the Supreme Court. Lawyers expressing various views, opinions on how they view the judgment by the 7 Supreme Court judges here. That long-awaited decision has finally been rendered. And you can say, finally, the BBI discussion has been dealt with by the judges, right from the High Court to the Court of Appeal, and finally at the Supreme Court. In total, 19 judges, because 5 judges at the High Court, 7 at the Court of Appeal, and 7 at the Supreme Court. In total, 19 judges. And that even not mentioning the amount of time that has been spent discussing the BBI matter in the political arena. And so from the legal precincts of the Supreme Court, I hand it back to you in the studio, even as we wait to hear what the political class will say out there, because I'm a political animal, so I would want to hear what the politicians say other than what the legal practitioners have been saying here. And on behalf of the team that has brought these live proceedings right from the Supreme Court, back to you, Vicky, in studio.
Fantastic. Thank you so much, Francis Gashuri, there doing an amazing job in breaking down this critical ruling from the Supreme Court. And of course, we'll be waiting to hear from their sentiments come Newsgang later on this evening. Let's cross over now to Mombasa to hear what regular Kenyans think about this ruling. Francis, what do you have for us from the coast?
Well, Victoria, from the port city of Mombasa, we want to talk to a few residents here with regard to the ruling by the Supreme Court judges that have just been delivered in Nairobi. And let me talk to one of them here. Songa hapa karibu, alafu tuambie labda majina yako, alafu mahakama kuu imeweza kutupilia mbali swala la BBI. Maoni yako?
Kwa majina naitwa Julius Ogogo, mimi ni Mkenya na mtetezi wa haki ya binadamu. Sisi kama shirika la kutetea haki ya binadamu tuko na furaha kubwa sana. Kwa sababu gani? The rule of the people has already prevailed. Hii mambo ya BBI ni kitu ambayo yani ililetwa kinyume cha sheria, na saa hii inaonekana wazi kuwa tayari ni kitu ambayo yani imepitwa na wakati. Na maoni yangu kwa hao wanasiasa ni kuwa sasa wanasiasa hakuna the loser, hakuna the winner on this. Sisi wote ni wana Kenya na inatakikana sisi tuungane pamoja no matter political affiliation. Ile kitu ambayo iko ni kuwa His Excellency the President Uhuru Kenyatta, his name has been dragged on this, but sisi kama wana Kenya hii kitu ilikuwa an initiative ambao ilikuwa project ya watu ambao ni watu binafsi, si haikuwa na maoni ya wa Kenya.
Labda imani ya idara ya mahakama kwako?
Sisi kama shirika na kama mwana Kenya halisi, sisi tuko na imani na mahakama wa Kenya, na inatakikana wawe namna hiyo na waangalie matako ya wana Kenya, kwa sababu kitambo tulikuwa hatuna imani na mahakama ya Kenya, na saa hii sasa inaonyesha wazi kwa tayari tuko na imani na mahakama ya Mombasa. Mahakama ya Kenya ni mahakama ambao kila mwananchi au mtu yoyote ambao yani ako hapa Kenya ako na imani na ako na raha mkunjufu, na tuko na imani sana kwa tayari. Hata verdict 2022, hata kama tutakuwa na presidential election, bado wa Kenya wote bado awe na imani na Supreme Court of the Republic of Kenya.
Asante sana. Acha tumpate kijana mmoja hapa. Majina yako, alafu tuambie maoni yako kuhusiana na kutupiliwa nje kwa swala hili la BBI.
Kama mimi naitwa Naanyu Singoi Samkweti, mimi ni mkazi wa huku Mombasa, mwanabiashara. Mimi nimefurahi sana mahakama kutupilia mbali hilo swala la BBI, kwa sababu hayajatusaidia kama sisi, hasa sisi wanabiashara, hayajatusaidia kwa kokote kule. Sasa mimi nafurahi sana kwa mahakama yetu ya Kenya wametupilia hiyo mbali, na nataka kuambia wanasimio they have just to go back to the drawing board, because they have messed up just from the beginning of this BBI. So we have just to change, and I would like to appreciate our court for ile kutupilia mbali hilo swala, kwa sababu inatusaidia kama Wakenya wote, na natumai kama 2022 we'll get the fact
Asante sana. Songa hapa karibu wewe kijana, pia utuambie maoni yako kama Mkenya kijana. Kutupiliwa mbali kwa BBI unaona kunaleta imani pia kwa idara ya mahakama. Majina mwanzo.
Kwa majina naitwa Lord Vika Sama Lovi. Aswa mi judgment ya mahakama sijafurahia kabisa.
Kwa nini?
Maana for me I believe BBI is initiative ilikuwa itulete pamoja. Definitely it was bring the youth. Ilikuwa ilete youth pamoja, ilikuwa na maana mzuri. Tulifuatilia sisi. Aswa mimi nilifuatilia kindani kidogo. So ilikuwa initiative ya kutuleta pamoja. Aswa president tayari alikuwa keshaongea, keshasema itatuwekea pahali, tutakuwa na mahala hata kama sisi vijana tutakuwa na pahali petu pale, aswa tunaweza sikizwa.
Baadhi ya mambo ambayo yameweza kuzungumzia ni kwamba kuna zile 70 constituencies ambazo zilikuwa zinasemekana ziweze kuwa created. Wakasema kwamba ni kinyume cha sheria jinsi ilivyopendekezwa. Wewe kwa maoni yako ni yapi?
Hiyo ilikuwa driven na politics. Mimi hiyo ni siasa tu. Maoni yangu ni kila kitu kilikuwa sawa. Hiyo ni politics tu.
Asante sana. Well, Victoria, there you have it from a section of residents of Mombasa speaking to us here. And they're saying that some are agreeing with the Supreme Court, and others are saying that they're not satisfied. But of course, the Supreme Court judges have already delivered their judgment. And now I want to hand you back to the studio for more of the reactions across the country.
All right, thank you so much, Francis Mtalaki, keeping us updated on sentiments from residents in Mombasa. Let's cross over now to Kisumu. Laura Atieno standing by there with a few voices as they react to the BBI verdict from the Supreme Court.
Well, indeed, Vicky, that judgment has come as a shocker to many residents of Kisumu, because if you remember, Kisumu County was among the top counties to pass the BBI document. So, of course, some of them were expecting that perhaps the court would dismiss, or rather not give much precedence to the previous, to the lower court's ruling. But I'm here just to hear it straight from the horse's mouth. Start with your name and tell us, now that BBI imeanguka, wewe kama mwananchi, maoni yako ni gani?
The fall of BBI is a clear portrait of the independency of our courts. I want to say that the expert of the judges have been consistent to say that Kenya has moved to a democratic space. We, as the citizens, we are comfortable. Even if it would succeed, still it will be okay. If it's now failing, then we are only asking for the government to bring for us another alternative. So we are asking the government to give us alternative, because BBI provided for a certain chapter that, to me, I have a feeling that it could have a positive impact to the people and the economy of the people. When BBI was acknowledging for increment of county budget allocation from 15% to 35%, for me, I really wish that it ought to have passed. 35% budget allocation would have created a positive impact on our economy. So at the same time, we might say that we regret for the failure of BBI. At the same time, we might say that Kenya is starting to show democracy. Yes. Okay.
Thank you very much. He has raised very pertinent questions. He says the document is not all good, but then it's not all bad. So what do you feel about today's judgment from the Supreme Court?
Yes, nitasungumuza lugha ya taifa letu ya jamhuri. Mimi nasema kulingana na BBI, mimi naweza sema watu wa judge najua wanasoma kuliko sisi, na wanajua kitu gani iko ndani, ndio wanatupa yeye nje. Na mimi nashukuru rais wetu wa Jamhuri ya Kenya Uhuru Muigai Kenyatta na pamoja na Prime Minister yetu Raila Amolo Odinga kuachie court nafasi afanye kazi yao, amalize. Sasa mimi nasema vile wanafanya namna hiyo sawa sawa, lakini kulingana na BBI watu jaji ndio wanajua kulingana na sheria yao na vile wanasoma sheria, wanajua kitu ambayo iko ndani yake mbaya, ndio wanatupa nayo nje. Sasa anajua sisi raia ajui chochote, sisi ni wananchi tu, lakini najua judge anajua kuliko sisi vile wanatupa nje. Sasa hakuna neno sisi naweza sema na deputy yetu William Ruto. Yeye pia ilikuwa nataka hii BBI atupe nje. Lakini asikuwe na raha ati yao imetupa, hapana. BBI si kura. Kura ni ya wananchi.
Naam. Shukran sana.
Asante sana.
Okay, start with your name and then tell us briefly what your sentiments are concerning the judgment today by the Supreme Court.
Okay, I'm Mr. George Awur. I think according to the verdict that has just been released, first of all, it shows the independence of the judiciary, that they are doing their work without any interference from any corner. Second, I want to appeal to all Kenyans to accept the verdict which has been released by the Supreme Court, because this is a process which has gone through the three main courts in Kenya. And if all these three courts maintain that it was unconstitutional, then we must all accept, because Kenya is governed by law, and we must all. We are a constitutional country, and this shows constitutionalism and the independence of all our arms of the government. So we must accept the verdict of the court.
Yeah. Thank you. Thank you very much. Briefly, let me just take one last person. I'll start with your name and tell us. The CJ has spoken about issues of people making comments outside the court and interfering, sort of trying to interfere with the judicial independence. What do you make of this as a resident?
My name is Victor Gembo. I'm the Secretary General of People's Parliament, Central Square, Kisumu. One thing that I would like to say about the verdict and the comment of CJ, Madam Koome, it's true that making comments outside the judgment, outside the courts, also do interfere, because they know the matters of the courts and the constitutions or whatever it says on everything. So we as citizens, we accept the verdict, though we may not agree, but they know why it happened. The only thing that I would like to say as a citizen of Kenya, we should be guided by the rule of the law. And the rule of the law may sometimes not work for us. So may not go as we expect. So the way it works, let's accept it and let's uphold peace and accept it. Raila knows, and we believe that at this time, the way he has been saying reggae will continue, he knows why, and we accept and we are with him. Baba Tosha.
Thank you very much. We'll take your views later on. But Vicky, as you have heard, residents of Kisumu all unanimously saying that they respect the court's decision and also calling on leaders to also do the same. So, of course, we will be looking at how the conversation takes shape in the coming days, and also how that the different opinions from different people will be affecting the different political ongoings in Kisumu County and its environs. Vicky.
All right, Laura Otieno there in Kisumu speaking to Kenyans on their reactions to the BBI verdict given out by the Supreme Court. Of course, a lot of analysis will be coming in our subsequent bulletins at 7 p.m. and at 9 p.m. And of course, the news gang will be digging deeper into what that means. We'll be waiting for the political discourse and how it shapes up over the weekend on the campaign trail. We'll have all of that for you come Saturday and Sunday. For now, though, we stop this broadcast, but we return you to your regular broadcasting, of course, until 7. Bye for now.